On our previous video, as concerned to meaning of consideration, we defined consideration as anything of value which has been exchanged between parties to a contract. On that case, I told you also that consideration needs not to be adequate, but it must be sufficient. Adequate means that consideration need not to be something big, large, or small. It can be anything, provided it is sufficient. And then sufficiency means here is that the consideration you furnish must be that which is recognized under the law as a normal. So the court will not be quick to hold you responsible for not living up to a particular standard or to interpret the minds of the party. That is to say, the court does not care whether this consideration is enough for you to hold this party binding to a particular contract. What the court needs to know is whether there was a sufficient consideration furnished. Once you have established that, there comes a contract. And today now we are considering types of consideration. What are those valid types of consideration that exist under the law of contract? Please, if you have not subscribed to this channel, I encourage you to do so because we post video here every single week that has to do with law and legal updates. Having said that, the court over the years has recognized three types of consideration. We have executory consideration, we have executed consideration, and then we have past considerations. Let us follow three of them seriatim to see how they meet. The reason for this is because these types of consideration, the understanding is key to actually be able to appreciate your problem question or to actually solve an issue that has to do with consideration under law of contract. So basically, when you are talking about executory consideration basically takes place when both parties' actions are still futuristic in nature. None of the parties has performed their actions. Everything is still futuristic, so to say. Executory consideration ordinarily is not often enforceable in the courts. Important point I want you to take home from executory consideration is the fact that executory consideration enforceability often depends on the terms of the contract. Most often than not, executory consideration cannot be enforced, but it depends on how the party construe their contract. Contract law is all about a question of fact. It's not often a question of law. So the court will look into the contract's facts, everything that transpired, to actually know whether these people their contract has gone to a point whereby any failure to meet up with a particular date, even though the constitution is still executory, either it will be enforced or not be enforced. I cannot single-handedly tell you or give you for fact that executory consideration is not enforceable or executory consideration is enforceable. It all depends on the fact of each case. And a contract, or you should know, and I will also make a video that has to do with types of contracts. You know that we have a contract by deed and also simple contract, formal contract and simple contract. Formal contract are those contracts that requires no consideration. So any contract that is made under deed often have no consideration. So the contract will still be enforceable even if it is executory in nature. So take it from me that executory consideration are those considerations that no party has furnished consideration yet. Everything is still under plan. They have agreed maybe on so week we are going to make cake for my birthday, and on those so day I'm going to pay you. Then any breach arising from this will be a question of fact before the court to either enforce it or not to enforce it, depending on the level of agreement between the parties. Now we go to the executed contract. Executed contract is the one that is strictly enforceable once you have met up with the requirement. Executed considerations occur when one party has performed their obligation under the contract and the other party promise is yet to be fulfilled. In this case, consideration is complete and enforceable at the time of the agreement. A locus classicus to illustrate executed consideration is none other than the case of Carlill and Carbolic Smoke Ball. In the beginning of my introduction to law of contract, I told you that you see this case of Carlill. If you are a year 2 student or a law of contract student, you must have that case in your brain. Number 6 must carry it. Whether you wake up, you should have that case on your lips because that case is not just a case. It is a locus classicus in law of contract. If you have watched all my videos starting from offer, acceptance, consideration, and so many counter offer, how to terminate an offer, I have often mentioned this case because it is the case that covers everything in contract, especially in first semester. So this case is to the effect, it is the case that established this principle of executed consideration. What do I mean by executed consideration? One party has performed his or her role to the contract. So you often see executed consideration coming into role when one party has made a promise, often to everybody. For instance, if a person made an announcement in a national newspaper that I'm looking for my child, whoever finds my child is going with 1 million. Whoever finds my child will be privileged to have a meeting with the president. Whoever finds these things often obtainable even in security apparatus, whereby the police can make a promise that anybody that we are able to disclose where these certain criminals are hiding, this and this. Anybody that fulfills that part of either doing that thing, either finding the thief, disclosing the identity, or making anything in fulfillment to whatever promise anybody has made, that person has performed what we call the executed consideration. What you just need at that point is to come to that person. Please, you say that I should find your goods. I have found your goods. See your goods here. Therefore, this contract is complete. The person is contracting to the whole world. The person is contracting to an unknown person. So executed consideration is often found in unilateral contract. That does not mean that executed consideration is limited to unilateral contract. It is often obtainable in supermarket. I will give you for instance, when you go to a supermarket, sometimes you make a payment. Then I want to buy so soap, I want to buy this, I want to buy that. You make your payment immediately. Then they will go and bring your this thing. In this case now, the consideration you have furnished has become executed already. And if they bring that, maybe mistakenly they bring that whatever you have bought from that shop, and you open it, something happened to you or anything go wrong with that very product you have bought, that place now you can institute an action because you have already furnished a consideration. And that consideration you have furnished can now afford you the privilege to maintain an action over anything that went wrong with that very product. Assuming you bought that product, is an edible something, you open it, maybe a Coke, you open it to drink, and you found that the thing is not good, or anything happened, you can maintain an action because you have executed the consideration immediately. You have fulfilled the consideration. This one is no longer futuristic. I hope somebody get my point. If you don't get my point, ask me in the comment section and I will explain to you. So that is basically what executed consideration is all about. It means when one party has fulfilled his or her own part to the contract has become executed. You have executed your own part. Then we go to the last types of consideration, which is past consideration. Past consideration refers to an act done before the promise is made. In English law, past consideration is generally invalid because it precedes the promisor's promise and does not constitute a bargain exchange. Past consideration is not a valid one under the law as far as common law is concerned. I will give you an instance. If there was an occasion in a particular, maybe Mr. President is hosting a ceremony, a party, and everybody was there, the dancer performed exceptionally well. One of the dancers performed exceptionally well, and to the amazement of Mr. President, or to the astonishment of Mr. President, he was very surprised, and he was like, wow, this girl, you did so well. I love your dance. In fact, you carried me on away. I'm going to give you 1 million. Mr. President has made a promise, right? Ordinarily, peccata sunt servanda. Man should honor their word. Peccata sunt servanda. It is a term in Latin maxim in contract law, which means that whatever you have said, it is expected that you honor it. In this case now, Mr. President has made a promise. Remember, the promise Mr. President made was not before the dance. It was not before the dance. Mr. President made the promise when the dance has happened. The dance has taken place before Mr. President, in state of joy, made the promise. So in this case now, if Mr. President refused to fulfill that promise later on, the person or the dancer to whom the promise has been made, the promisee, cannot enforce that contract because there has been what the person has actually furnished consideration by dancing. But in this case, the consideration is a past one. It came before the promise. But had it been Mr. President was like, whoever was the best dancer in this very song, I'm going to offer that person 1 million. Anybody that meets the requirement of dancing exceptionally and that criteria will be deemed to be worthy of receiving whatever dividends that is coming from that contract. And failure of Mr. President will make him liable under the law of contracts Hope you get the point. Executed past consideration is not a valid one. You should just have it in mind that past consideration basically come into play when you have carried out a particular action that attracted the promise made to you. That is what past consideration is all about. I'll take that again. Past consideration occur when you have carried a particular action that attracted the reward or promise you seek to enforce in the court. This is where the lecturer is going to test you. You're going to put a lot of things to actually know whether you understand what past consideration means. And we say that past consideration is not a valid one in law. An important case that illustrates what we just said now is the case of Roscorla and Thomas, a case decided in 1842. It is a very serious case that established the principle that past consideration is not a valid one in law. According to that case, where the promise to provide a guarantee for the soundness of horse after the sale was deemed unenforceable. In this very case of Roscorla and Thomas, the court held that the promise to provide a guarantee after a horse has been sold is not actionable or is not enforceable. The promise to provide a guarantee after the sale of a horse has been made is not possible or is not enforceable. I hope you get that point. The people have transacted, they have sold a particular horse. The court here is not enforceable because in this case, everything has transpired. You have made a consideration, you have furnished a condition, you have gotten your horse. Whatever thing you are looking for in this case is another fresh entire contract. It's another fresh contract you are seeking for, not in addendum. So this case of Roscorla and Thomas is another important case to look into so that you get used to the fact of the case. And I also encourage you, we have made the video introduction of contracts. We have made video on various elements of contract. We started by offer, acceptance, counter offer, whether it's a valid one. We also made video on how to terminate offer. Go to my playlist. If you go to my playlist, check for contract law videos and any other video you may be looking for. Every one of them is there and all of them is geared towards helping you as a law student. Please, here we release a video every single week. I encourage you to subscribe, and not only doing that, when you are doing that, turn on the notification button. Press it and turn on the notification button so that when we post a video, you will see it as a notification. The video might be the one to help you so you can easily watch it and stay updated. That is the beauty of an online courses like this. I encourage you also to keep being a part of this community. Always remember to like our video. Yes, it means a lot. It really shows us and me personally that actually somebody is really finding value into this video. Please like the video, share with your friends, and I will see you in my next video. Click the video above to see more video on elements of contract. God bless you.